Abiola and Starco Insurance PLC.
Okay. Yes, parties absent.
Yes, my lord.
Yes, Clement Council, Mr.
Akinwumi Salau.
Akin. Is he here?
Yes, he has been here. Is it
I can see Galaxy A30 and Galaxy A20. Okay. Mr. Okesanya, is Mr. Okesanya part of the?
No, he's one of the claimants.
Okay.
In LBI cities.
Okay. Okay, Mr. Salau is joining us. Mr. Akinwumi Salau.
Okay, he's there.
It's Mr. Salau. Mr. Salau.
Yes, he's mute.
Okay, Mr. Salau, you are muted. Mr. Salau, you are muted.
Okay. Okay.
Good morning.
Good morning, my lord.
How are you?
Fine, my lord.
Well done.
Yes, my lord.
Yes, you are in this matter about the
Yes, ma'am.
Okay.
Yes, my lord. I'm representing the claimant. Akinwumi Salau.
Yes. Yes. So Aja is LA 8620
2020.
2020.
Okay. Yes, Ms. Salau.
My lord, we filed terms of settlement dated 27th day of July 2021.
Yes.
And therein are contained the terms agreed upon by parties.
It's dated.
It's dated 27th of July.
Yes.
2021.
Okay, yes.
And with the time permission of your lordship.
Yes.
I seek to adopt the terms of settlement, my lord.
Okay.
I'll be urging your lordship to make the terms of settlement the judgment of the court in this case.
Okay. When was it filed?
It was filed on the 28th July.
Okay. So terms of settlement dated 27th of July 2021, but filed on the 28th of July 2021, duly signed by the parties and the respective council and adopted by Learned Council for the claimant is hereby entered as constant judgment of the court.
As the completes.
Mr. Salau, thank you so much.
We are most grateful, my lord.
Thank you.
Yes, Father.
Yes, Mr. Adebayo. Aja, you can call the...
Okay, Suit number NICN/L/540/2020 between 1. Olatubosun Owolabi, 2. Wasiu A. Akinsanya, 3. Olufunmilayo Adebisi, 4. Emmanuel O. Okesanya, 5. Oluwatoyin F. Jolaiya, 6. Usamot O. Shekoni, 8. Oladipupo S. Adetomiwa, and 9. Folashade O. Taiwo.
At present.
Yes, I know. And Lagos Building Investment Company PLC. My lord, 1st, 5th, and 9th claimant present.
Okay, and 9th claimant.
Present.
Yes, other parties absent.
Yes, my lord. Defendants absent.
Yes, Mr. Adebayo.
Please, Honorable Court, my lord.
AI. Yes. For the claimants.
Adebisi Olufumlayo is present.
Eh?
Adebisi Olufumlayo is present.
You're one of the claimants.
Third claimant.
Okay, so
okay. It will now be 1st, 3rd, 5th, and 9th claimant. 1st, 3rd, 5th, and 9th claimant.
Okay. Yes, Mr. Ridwan.
Mr. Olabi is present. Please. Real one or part of it?
Mr. Olabi is the 1st claimant.
Who is the 1st claimant?
Olatubosun.
Okay.
That's the 1st.
Okay.
1st, 3rd, 5th, and 9th.
Mr. Rilwan is Rilwan of Patutumba.
Yes, Your Lordship, Rilwan of Patutumba. Appearance for the defendant.
For the defendant.
Thank you.
So this is my judgment.
Please mute yourself so that there won't be distractions.
Yes, I think they are all muted. So this is my judgment. The claimants commence this suit by a complaint dated 17th of December 20. And grossly undercalculated is contained in this defendant's staff handbook and which form part of the claimant's contract of employment before the collective agreement as concluded between the Nigerian Employers Association of Banks, Insurance, and Allied Institutions, then the trade associations to which the defendant belongs, and the Association of Senior Staff of Banks, Insurance, and Financial Institutions, ASBIFI, being the trade union of the claimant. Number 3, a declaration that the redundancy, severance, and other benefits of the claimants ought to be calculated in accordance with the provisions on severance benefits contained in the 2005 collective agreement that's in force, regulating the employment of the claimants, and which was concluded between the Nigerian Employees Association of Bank, Insurance, and Allied Institutions, then the trade union, trade association to which the defendant belongs, an association of senior staff of banks, insurance, and financial institutions as BFI, then the trade union of the claimant. Number 4, a declaration that the conduct of the defendant toward the 9th claimant during her pregnancy and maternity period leading to her being coerced to resume back to work during her maternity leave for purposes of being disengaged amounts to an unfair labor practice on the part of the defendant. Number 5, a declaration that the defendant has no justification or legal basis withholding the 9 claimants' redundancy terminal benefits, and the conduct of the defendant in this respect amounts to an unfair labor practice. Number 6, an order compelling the defendant to pay to all the first 8 claimants jointly and severally the sum of 85,143,565 naira, then the aggregate of the outstanding payment due to all the first 8 claimants in accordance with the scheduled breakdown of the respective individual entitlement of each of the claimants using 2005 CBA as pleaded in the Schedule 6 attached to the statement of claim and relied upon at the trial. Alternatively, to Relief 6, an order compelling the defendant to pay to all the first 8 claimants jointly and severally the sum of 24,045,936 naira 85 kobo, being the aggregate of the outstanding payment reasonably in the least due to all the first 8 claimants in accordance with the scheduled breakdown of the respective individual entitlement of each of the claimants using the defendant's staff handbook as pleaded in the Schedule 7 attached to the statement of claim and relied upon at the trial. Number 7, an order compelling the defendant to pay to the 9th claimant the sum of 1,641,919 naira 13 kobo, being the aggregate of the outstanding payment due to the 9th claimant in accordance with the table stroke schedule of breakdown of the entitlement of the 9th claimant as pleaded in the schedule attached to the statement of the claimant and relied upon at the trial. Alternatively, to Relief 7, an order compelling the defendant to pay to the 9th claimant the sum of 84,346 naira 41 kobo, being the aggregate of the outstanding payment reasonably in the least due to the 9th claimant in accordance with the table / schedule of breakdown of the entitlement of the 9th claimant using the defendant's staff handbook as pleaded in the schedule attached, 607 attached to the statement of claim and relied upon at the trial. Number 8, an order compelling the defendant to pay interest on the sums respectively claimed in Reliefs 5 and 6 above at the rate of 2% per annum from July 2017 till judgment, and thereafter on judgment sum at the interest rate of 2% per annum till the sale sum is liquidated. Number 9, damages in the sum of 2,500,000 naira in favor of the 9th claimant for the unfair labor practice of the defendant against the person of the 9th claimant. The defendant, in reaction to the claimant's suit, entered appearance and filed a statement of defense on the 2nd of March 2021 by leave of the court. Meanwhile, the claimants also filed a reply to the defendant's statement of defense on 12th of July 2021, which was deemed to have been properly filed and served. Case of the claimant. From the pleadings filed by the claimant and their testimony, they are former employees of the defendant who were summarily disengaged by a new management of the company on the ground of redundancy. It is the case of the claimant that the defendant should change them in computation of their entitlement after being relieved of their jobs on the ground of reorganization of the company. Claimants also maintain that the defendant failed to compute the redundancy benefit using the collective bargaining agreement and oil company handbook. Claimants further stated that the defendant is withholding the terminal benefit due to the 9th claimant as calculated by the defendant, and that the conduct of the defendant towards the 9th claimant when she was pregnant and during her maternity leave amounts to unfair labor practice. Case of the defendant. The defendant case is that upon the claimant's disengagement, the defendant committed to pay them a block payment as ex gratia payment on compassionate grounds upon the intervention of the union as BP. that the claimants are receiving the agreed payment did not raise any alarm or dispute the payment until 2 years after, when they turn around to claim that their employment was disengaged on the ground of redundancy, purportedly entitling them to redundancy benefits as contained in the defendant's employee handbook and an expired 2005 collective bargaining agreement, which is non-binding on the defendant, as the said agreement had never been incorporated into the claimant's employment contract with the defendant. Trial. Trial commenced on the 30th of June 2021, where CW1 testified by adopting his two witness statements on oath dated 22nd of December 2020 and 12th of July 2021, respectively, and tendered the following documents as exhibit. Number 1, employment letters and confirmation letters, exhibit LB 1A to T. Number 2, promotion letters, exhibit LB 2A to R. Number 3, termination letters, exhibit LB 3A to R. Number 4, LBIC handbook, exhibit 4. Number 5, collective bargaining agreement, exhibit LB 5A to R. Number 6, schedule of redundancy entitlement, exhibit LB 6A to J. Number 7, letter dated 16th of October 2019, exhibit LB 7. Number 8, letter dated 11th of December 2019, exhibit LB 8. Number 9, letter dated 20th January 2020, exhibit LB 9. Number 10, letter dated 3rd of March 2020, exhibit LB 10. Letter dated 28th of December 2016, exhibit LB 11. Number 12, letter dated 26th of April 2017, exhibit 12. Number 13, letter dated 4th of May 2017, exhibit 13. Number 14, demand letter, exhibit LB 14. Number 15, letter dated 1st of December 2020, exhibit 15. And number 16, statements of account, exhibit LB 16. CW1 was thereafter cross-examined by learned counsel for the defendant, and as there was no re-examination, he was then discharged. On the 2nd of March 2022, CW2 also testified by adopting as witness statement on oath dated 22nd of December 2020 and the 12th of July 2021, respectively. CW2 was thereafter cross-examined by learned counsel for the defendant, and she was discharged as there was no re-examination. The defendant opened his case by calling his sole witness, Ekpa Olorunfemi, DW1, who adopted her witness statement on oath dated 8th of March 2022 as her evidence in chief. DW1 was cross-examined by the learned counsel for the claimant and re-examined, where the defendant closed his case and the matter was adjourned for adoption of final written addresses. Defendant's final written address. Defendant's final written address dated 1st of November 2022 was filed on the 2nd of November 2022, wherein one issue for determination was submitted to it, and I quote, whether having regard to the claimant's pleadings and evidence laid in support of the claim before this honorable court, the claimants have succeeded in improving their case against the defendant to entitle them to the relief sought in this matter. Unquote. Learned counsel for the defendant submitted that servant and master relationship is governed by the terms of the employment contract between the parties. That a private employer disengaging the service of an employee is at liberty to state the reasons for such termination. And where no reason is given, the employee cannot infer the reasons of his termination as long as the employer complies with the provisions of terminating the appointment of the employee. Counsel referred to the case of Adibua and Mobile Oil Nigerian PLC, citation given. In the circumstances when redundancy contrary to termination or resignation could be said to have occurred. Counsel further submitted that the trigger, that in the pleadings of the claimant and during cross-examination, they did not establish that the defendant declared their employment as redundant in their letters of disengagement to entitle them to the monetary compensation applicable thereto. Learned counsel argued that the claimants, upon realizing that they are not entitled to redundancy benefits, having not been declared as redundant, sought the intervention of their membership union to contend that they are entitled to redundancy benefits, and upon the intervention of the SBP, the defendant, irrespective of what the benefit the claimant believed, they are entitled to agree to pay certain sums of money to the claimant ex gratia. Counsel also stated that 2 years after the claimants were paid, the defendant received letters from the claimant solicitors after negotiation and payments had been concluded. The submission of counsel that the claimant's contention that their union did not properly represent them is belated. Submission of counsel on 2005 CBA that the position of the law on validity of collective bargaining agreement is that irrespective of the parties involved or the terms stated therein, a collective bargaining agreement is non-binding and unenforceable as between an employer and an employee, except it has either been referenced or incorporated into the terms of employment of an employee. Undoubtedly, 2005 CBA had expired in 2007. The claimants and the defendant not being a party to it did not and could not have breathed a new lease of life into it by incorporating or referencing it into the terms of employment or the employee handbook. The claimants have failed to prove to the court that 2005 CBA was incorporated into the terms of employment or the defendant employee handbook, and it's elementary that an agreement to which the defendant was not privy cannot be enforced against it to effect its legal right. Counsel referred to the case of Unwajagu and British American Insurance Company, UBN PLC, and source citation supplied. It is submission of counsel that the court has no duty to speculate on possible fact given by a party in a proceedings, that the evidence of the ninth claimant in this suit on claims for special damages cannot be relied upon, as the ninth claimant has failed to strictly prove in accordance with the requirement of the law the existence of fact contained in a witness deposition. Counsel submitted that the defendant was not under any obligation to honor the agreement brokered by ASBF on behalf of the claimant, but nonetheless honor same on compassionate grounds, that the claimants are not allowed to reverse their position 2 years after being paid the amount brokered by the representative and been paid their benefits, such in the case of Ntung, Long Wang, and Section 151 of the Evidence Act. It is the first submission of counsel that the claimants having received their entitlement as contained in the contract of employment and further ex gratia payment arising from negotiation with ASBF and failed thereafter are stopped from disputing full acceptance of the payment. Counsel further submitted that the letter dated 20 January 2020, admitted as Exhibit 9, was marked without prejudice. And the position of the law is clear that a letter or any form of communication between the parties to an action, when marked with the words without prejudice, should not be admitted. Counsel refer the court to the case of Standard Construction Limited and a higher citation given. Counsel submitted that with respect to the ninth claimant, the defendant contended via DW1 that she held the defendant's mortgage documents contrary to the instructions in the letter of disengagement, which requested that all bank assets in their possession should be handed over to the Human Resources Department. The submission of counsel that it is in line with the defendant's letter of disengagement and employee's handbook that the defendant withheld the ninth claimant entitlement in total sum of 555,000 naira as contained in the letter dated 28 July 2017, as the defendant could not commence a disciplinary action against the ninth claimant having disengaged her employment. That the ninth claimant is not at any time entitled to the sum of 1,641,000 naira or 84,000 naira interest and damages thereon. Claimant's final address. Claimant's final address, which is dated 17th of November 2022 and filed on the 18th of November 2022, contains two issues for determination to it. Number one, whether by the combined reading of exhibit LB3A to R, LB9, and LB16, as well as the admission of the defendant in exhibit LB15, the disengagement of the claimant cannot be said to be on the ground of redundancy and the defendant liable to compute in a transparent manner the redundancy severance benefit of the claimant align with the applicable condition of service in the defendant's company. Number two, whether the withholding of portion of the ninth claimant's terminal benefit by the defendant on the mere allegation that an unspecified amount document of the defendant is being withheld by the ninth claimant can be justified in any respect. And if not, whether the ninth claimant is entitled to a specific reliefs against the defendant on the said outstanding payment and their unfair labor practice against the person of the ninth claimant. The counsel submitted that due to the change of management in the defendant's company, the claimants were relieved of their job on the ground of redundancy. And even though the defendant denied that the claimants were disengaged on the ground of redundancy, but no reason was given for termination of the appointment at that time. Counsel also submitted that by the combined reading of the exhibit LB3A to R, LB9 and LB16, as well as the admission of the defendant in the exhibit LB15 and the clear evidence of the claimant's witnesses, the conclusion this honorable will find is that the claimant's employment, despite the denial of the defendant, were terminated on the ground of redundancy. It was further submitted that oral evidence would not be allowed to contradict documentary evidence. Citing Section 128 of the Evidence Act 2011, the case of MTN Nigerian Communication Limited and C Soka Nigeria Limited and Agbera and Mimra, citation given. Counsel contended that the defendant made it known a non-fact to them from the point of their disengagement that termination was on ground of redundancy, that this fact is consistent with what the defendant on his own gave express instructions to the bank to indicate to the claimant that the payment be made to each and every one of them were for the termination of their employment on ground of redundancy as shown in exhibit LB16. Counsel also referred to paragraph 2 of exhibit LB15 dated 1st of December 2020. The submission of counsel that the defendant cannot be mistaken in all the documents where it on its own indicated in clear words in writing and expressly that the claimant's employment was terminated on the ground of redundancy. The import of what the defendant described as strategic reorganization aimed at repositioning the bank for growth and profitability in Exhibit 9 cannot have a different meaning from what it's meant by redundancy, as specifically used by the defendant in the several other documents in this case. It was contended by the claimant that the court cannot confine itself to the defendant's reason for termination of the claimant's employment to Exhibit LB3A to R. The position of the law is that where the terms of a contract are contained in several documents which are connected to each other, the document must be read together and no single document should be construed in isolation. Also refer the court to the case of Orakwe and Orakwe, UBA and AP Resort, Ransom Industrial Limited and Avia State Commissioner for Health and Social Welfare, citation supplied. It is the first contention of counsel for the claimant that the true intention relating to the purport of the termination of the claimant's employment Exhibit 3 cannot be garnered without recourse to the other documents like Exhibit 9, 15, 16, which are all documents emanating from the same defendant and given to the claimant. Counsel argued that the law is that an employee's severance terminal benefit cannot be unjustifiably withheld and was said to have been waived, referring to the case of Julius Baga and Mwagu, NMPC and Obeche, and Section 210 of the 1999 Constitution. Counsel further argued that the categories of documents that are excluded by the provision of Section 26 of the Evidence Act are documents made in the course of negotiation in any matter of dispute, but where the document is in the form of an admission, as Exhibit 9 in this case, and is so marked without prejudice, such document is admissible in law, such in the case of EcoBank and Dynamics Limited. It was the further argument of counsel that in the instance case, Exhibit 9 was not a document made in the course of any negotiation, that it was indeed an admission by the defendant of his position with respect to the claim and demand made against the defendant by the claimant solicitor, particularly on behalf of the ninth claimant. Counsel submitted that the only reason why the defendant is denying the obvious fact that the claimant's employment was terminated on the ground of redundancy is simply because the defendant knew that it did not compute and or pay the claimant their due entitlements, stroke terminal benefits in line with the condition of service in operation in the banking sector at the material time. In this case, parties are ad idem that Exhibit 4 forms part of the condition of service that's applicable to the claimants and the defendant's bank. The defendant, however, knew that it had not computed the terminal benefit and entitlement of the claimant, even in line with and or using the condition of service in operation in the defendant bank. Or any existing or non-condition of service at the material time. It was a submission of counsel that the defendant under a new management made it known to the claimant at the point of their disengagement in July 2017 that they had been relieved of their jobs on the ground of redundancy, and what the defendant described as a strategic reorganization in the company. This was further captured and reflected writing by the same defendant in its several documents and communication to the claimant. The defendant is stopped by its conduct from contending that the claimant's employment was not terminated on the ground of redundancy. Counsel referred to Section 169 of the Evidence Act 2011. Counsel further submitted that it is instructive to note further that the defendant stated as part of the component in the exhibit LB3 an ex gratia amount being paid to the claimants without any explanation in any document on what the said amount represents and how it was computed. The claimant were neither informed nor notified in any document what the said ex gratia represents in exhibit LB3. But the defendant's witness stated under cross-examination at the trial that the said ex gratia amount was a generous payment by the defendant to the claimant. The submission of counsel that this sort of payment can never be a substitute for what the legitimate redundancy severance terminal benefit that is due to the claimant. The other counsel submitted that claimants were not paid what is legitimately due to them as the redundancy terminal benefit by the defendant. Counsel referred the court to Exhibit 7, which was a letter addressed to the defendant and capturing the grievances of the claimant and the demand for the computation and payment of the outstanding redundancy benefit to the claimant. In the said Exhibit 7, the claimant premised their claim for the outstanding redundancy benefit on Exhibit 5, which was the 2005 collective bargaining agreement that was in operation in the banking sector at some point in time in the country. Counsel further submitted that in another letter dated 12th of November 2022, Exhibit 15, the claimant reiterated the basis of their claim and further called for the proper computation and payment of the redundancy terminal benefit. The defendant, however, failed to accede to this request by the claimant. Claimant submitted that in a bid to clearly demonstrate to the defendant what the claimants are duly entitled to, the claimants attach Claimants submitted that in a bid to clearly demonstrate to the defendant what the claimants are duly entitled to, the claimants attached to Exhibit 7 and 15 what they consider to be the appropriate computation of the redundancy benefit, since the defendant had refused to respond to Exhibit 7, where the claimant demanded for the basis of the computation of payment that was made to them. In fact, the claimants equally went further as far as using Exhibit 4 as the defendant employee handbook to equally compute the redundancy. Counsel submitted that the defendant witness in this case, both in her evidence in chief and under cross-examination, admitted that Exhibit 4 was the external policy of the bank that regulates the condition of service in the defendant company at the material time, and that same equally serves as the basis of which the claimant's employment were terminated. However, the defendant witness confirmed at the trial that Exhibit 4 has no provision for ex gratia. And likewise, that the same Exhibit 4 contains provision for computation of redundancy benefit, which is not used in the computation of the claimant's severance benefit. Counsel further submitted that the defendant had contended in his evidence, and counsel addressed in this case that this court should not countenance the said Exhibit LB6AJ simply because, according to the defendant, the said documents were made prior to and while this litigation was being contemplated on the matter. It is submission of counsel that the contention by the defendant is untenable because the defendant had failed to respond and honor the demand of the claimant that the retirement benefit must be properly computed using the non-parameters set out for the computation of redundancy benefit. The defendant, having disengaged the claimant's employment in the manner it did, is expected to an honor obligation to compute the claimant's terminal benefit appropriately in accordance with the law, which is either on the basis of the prevailing condition of service in the banking sector in the country, or in the list as contained in Exhibit 4, which was in place in the defendant company at the material time. The defendant, having not done that, has left the claimant with no option than to compute what they believe is legitimately due to them using the parameters set out in Exhibit 4 and 5 respectively, that the defendant is expected to use in the computation of the redundancy terminal benefits. Counsel submitted that it is not in dispute in this case that Exhibit 5 clearly makes provision for its duration. This point is well considered, but the point being looked upon is that, considering the fact that the said collective bargaining agreement between NIABIA and ASBP, which are the trade union of the financial institution and their workers in the country, it's not out of place that same be used as the benchmark for computation of redundancy benefit of workers in the sector, and the claimant in this case, citing the case of Honorable Chigozie Eze and Governor of Abia State. It is a submission of counsel that this honorable court, as a court of justice, has the power to make necessary inference and adjudicate on the dispute between the parties in this case, and make finding that will serve the justice of the case by accepting the computation of the claimant's redundancy benefit using the parameters set out in the said Exhibit 5 as illustrated in Exhibit 6, reliance on Exhibit 4 in the computation of the alternative claim. The counsel submitted that the claimants have pleaded and testified in this case that it is provided in Exhibit 4 as shown particularly at subparagraph 3 under the provision for redundancy. The counsel submitted on issue 2 that the ninth claimant, aside from the general claim that she has with the other claimant in this case, further pleaded and gave evidence on the fact that the terminal benefit that was arbitrarily calculated for her by the defendant was equally not paid in full by the defendant. Now, the ninth claimant further testified as to the unfair labor conduct of the defendant towards her during her pregnancy and the eventual termination of her employment. Counsel referred the court to the claimant's pleadings and specifically to the ninth claimant's evidence on same paragraph 32, 33, and 34 of her written statement on oath, dated 2nd of December 2020. The defendant, in his defense and evidence, admitted that it truly withheld a portion of the ninth claimant's severance terminal benefit on the allegation that the ninth claimant has refused to release to it an unspecified title document. The submission of a counsel that the defendant has not shown or established any justification for withholding the ninth claimant terminal benefit in this case, and the allegation by the defendant that the ninth claimant withheld his document remains unsubstantiated prior to the institution of this case, even while correspondence were being exchanged on the issue and also at the trial of this case. That throughout the defendant's correspondence and other cross-examination of the defendant witnesses, the defendant could not state or give any iota of particulars of the alleged document said to have been withheld by the ninth claimant. That the law is clear that he who alleges must prove certain sections 131 and 132 of the Evidence Act. It was contended by counsel for the claimant that the conduct of the defendant, particularly against the ninth claimant, aside from the withholding portion of terminal benefit on spurious and unfounded allegation, equally amounts to an unfair labor practice going by the maltreatment method to the ninth claimant during her pregnancy and eventual disengagement from the defendant's employment. That, as shown in Exhibit 12 and 13, the ninth claimant was tactically recalled to work from her already approved and granted 3 months maternity leave that was later cut short so that the defendant could terminate her appointment in July 2017. Defendant replied on points of law to the claimant's final written address. The defendant filed its reply on points of law on the 13th of December 2022, where the Learned Counsel submitted the contrary to position of the claimant that this court has a judicial respect of the contract of employment to apply international level and global best practice in termination of whether the claimant's employment were rightly terminated. That the position of the law on termination of employment between an employer and an employee in Nigeria remains as stated in the case of NDA and Ayedogun, citation given. Counsel for submitted the law as stated by the Court of Appeal in above case is that where there is any contention by the disengaged employee about termination, what the court will look at is whether the employer complied with the terms of the contract of employment between the parties. So this is my opinion. Upon careful perusal of the pleadings filed by the parties, the evidence adduced, and the submission of the respective counsel, the main issue upon which this case will be determined is whether the claimants have been able to prove their case to be entitled to the reliefs sought. The grievance of the claimants against the defendant, as earlier stated, is that they are former employees of the defendant who were summarily disengaged by a new management of the company on the ground of redundancy and should change in computation of their entitlements. The defendant failed to compute the redundancy benefit using the company's handbook or the 2005 collective bargaining agreement in the banking sector. Claimants also stated that the defendant is withholding the terminal benefits due to the ninth claimant as calculated by the defendant, and that the conduct of the defendant toward the ninth claimant when she was pregnant and during her maternity leave amounts to unfair labor practice. The defendant, however, contended that it paid the claimants a block payment as ex gratia on compassionate ground upon the intervention of their union as before. The claimant and the bid to found their claim with a view to discharging the burden they bear, presented among others their employment letters of termination of employment, the defendant's handbook, collective bargaining agreement, schedule of redundancy and treatment of the claimant using 2005 CBA and LBIC handbook, copies of statement of account of the first, second, third, fifth, seventh, and eighth claimant. It is pertinent to observe that in determining the key issue raised by the claimants, the defendant bank terminated their employment on the ground of redundancy, or that they were terminated as contended by the defendant in compliance with the terms of their agreement. Recourse shall be held to the terms of the agreement and, of course, the conduct of the parties. In law, once parties out of their own free will and volition enter into a written agreement, there should be a law bound to honor and be bound by the terms of their agreement, and therefore the relationship and subsequent disagreement must be resolved in accordance with their agreement, and the court cannot go outside the terms as agreed upon by the parties. It was held in Ahmed and CBN that parties are bound by the terms of their contract, and the court cannot read into such contract what was not within the contemplation of the parties, except where fraud, duress, or misrepresentation can be established. It is instructive to add that the terms of the contract between the parties are clothed with some degree of sanctity, and if any question should arise with regards to the contract, the terms in any document which constitute the contract are unquestionably the guide to its interpretation. It's not within the purview of the court to write a contract for the parties. See the case of Minaj Holdings Limited and Amcon. Let me refer to Chapter 5 of Exhibit LB4, which talks on redundancy as follows, and I quote, redundancy is understood to mean the involuntary loss of employment through no fault of the employee caused by an excess of manpower or a contraction of available work through costs beyond the control of the company. Number 2, in all cases, the principle of last in, first out shall apply except where the merit and ability of a less senior employee is, in the management's opinion, greater than that of an employee with longer service. Number 3, any employee declared redundant shall be entitled to monetary compensation on the following basis. Number 1, less than 5 years of service, 6 weeks basic salary for each completed year of service. Number 2, 5 years but less than 15 years, 8 weeks basic salary for each completed year of service. Number 3, 15 years and above, 10 weeks basic salary for each completed year of service. The above payments shall be made without prejudice to the employee's entitlement to appropriate notice or salary in lieu of notice as specified in the employee's letter of employment. Unquote. Article 5 of Exhibit 5 also states as follows. Number A, redundancy is understood to mean and means, in the context of this agreement, the involuntary loss of employment through no fault of the employee caused by excess of manpower of contraction of available work through causes beyond the control of the employer. In the event of redundancy arising in any member establishment and before any employee is declared redundant, there shall be consultation between the National Secretariat of the Union and the Secretariat of the Association. Number C, in all cases, the principle of last in, first out shall apply except where the merit and ability of a less senior employee are, in the management's opinion, greater than those of an employee with longer service. Number D, any employee declared redundant shall be entitled to monetary compensation on the following basis. Banking group, less than 5 years of service, 12 weeks total emolument for each completed year of service, 5 years less than 15 years, 14 weeks total emolument for each completed year of service, 15 years and above, 16 weeks total emolument for each completed year of service. And unquote. Just abided by the claimants at paragraph 15 of their statement of fact that the payment description and or narration used by the defendant in the respective payments related to all of them were titled redundancy. It can also be observed that the defendant in Exhibit 15 admitted to paying the claimant the full and final settlement of the redundancy benefit, which was brokered by the Association of Senior Staff of Banks, Insurance, and Financial Institutions, (SBP), and duly accepted by the claimant. DW1 also admitted under cross-examination that the statement of account of the claimant Exhibit 16 emanates from the defendant, and that the payments made were redundancy benefits given to the claimant. DW1 further stated that she was not aware of any communication that there is a mistake in Exhibit 16, even though the defendant contended that the payment made to the claimant was an ex gratia payment done in accordance with the terms of the agreement. But I observed that there's nothing like ex gratia contained in the claimant's letters of employment, Exhibit 1, or the employee's handbook, Exhibit 4. Going by Exhibit 9 and 16, it can be observed that even though the defendant did not mention the word redundancy in the letters of disengagement of the claimant, but I find from its conduct on Exhibit 9 and 16 that the payment it made to the claimant was for redundancy benefit. It now remains to ask whether the claimant's redundancy benefit will be paid in accordance with the 2005 collective bargaining agreement or the defendant's handbook. It is contended by the defendant that the 2005 collective bargaining agreement had expired, but the claimants have asserted that they are members of the SBP. However, to prove membership of a union, one has to present evidence of its membership or payment of check-up dues. However, I have not come across throughout the evidence adduced by the claimants any proof of their membership to the SBP, even though there was a pleaded fact to that effect. But suffice it to say that pleadings not supported by evidence go to no issue. Therefore, the claimant's principal relief that they are entitled to redundancy benefit based on the 2005 collective bargaining agreement is declined. However, it is noted that the claimants have alternative reliefs on redundancy pay in accordance with the defendant's handbook, and it is tried that a main claim and alternative relief cannot be granted at the same time. Where a claim is in the alternative, the court should first consider whether the principal or main claim ought to have succeeded. It is only after the court may have found that it could not for any reason grant the principal or main claim that it will then consider the alternative claim. In other words, an alternative award is an award that can be made instead of another. It is a separate claim and a separate award. It's not an additional award. Otherwise, it will amount to double compensation, which must be avoided. See the case of GK Investment Nigeria Limited and Nigerian Telecommunications Limited. Therefore, having earlier found that the claims are entitled to redundancy benefit, they should be thus paid in accordance with the company handbook exhibit LB4 as computed in schedule of redundancy entitlement of the claimant using the handbook exhibit LB6A to J. As for the claim for damage in favor of the ninth claimant for unfair labor practice of the defendant against her person, it was held in the case of Afolabi and Ola that general damages are only awarded where there is a breach. The law is settled that general damages are such that necessarily flow from the wrongful act of the defendant as claimed and established by the claimant, although it does not need to be specifically pleaded and proved like special damages. General damages are said to be implied or presumed from the proximate, direct, or immediate result of the act of the defendant that the claimant complained of, and it is normally grantable at the discretion of the court, taking into consideration the peculiar circumstances of the case and guided by the judgment or standard of a reasonable man. See the case of Garba and Ku, Oyster and Fair Lakes Hotel. The principles governing award of damages, particularly general damages, were clearly enunciated that damages are sums of money given to a successful claimant for a loss or harm of any kind. Considering the above and bearing in mind the facts and circumstances of this case, I'm not satisfied that the ninth claim is entitled to damages. On the whole, and for the reasons given above, the claimant's case succeeds in part, and for the avoidance of doubt, I hereby make the following declaration and orders. Number one, a declaration that the payments made by the defendant to the claimants upon termination of their respective employment were undercalculated and underpaid by the defendant. Number two, a declaration that redundancy benefits of the claimants ought to be calculated in accordance with the provisions of severance benefit contained in the defendant's staff handbook. Number three, a declaration that the defendant has no justification or legal basis withholding the ninth claimant's redundancy benefit. Number four, an order compelling the defendant to pay to all the first to eighth claimants jointly and severally the sum of 24,045,966 naira 85 kobo, being the aggregate of the outstanding payment due to all the first to eighth claimants in accordance with the schedule of breakdown of the respective individual entitlement of each of the claimants using the defendant's staff handbook. Number five, an order compelling the defendant to pay to the ninth claimant the sum of 84,346 naira 41 kobo, being the aggregate of the outstanding payment due to the ninth claimant in accordance with the table/schedule of breakdown of the entitlement of the ninth claimant using the defendant's staff handbook. Number six, judgment sums shall attract 10% post-judgment interest per annum until they are fully liquidated. Number seven, reliefs 3, 4, 6, 7, and 9 are hereby declined. Judgment is entered accordingly with a cost of 200,000 naira in favor of the claimants against the defendant.
As the court places.
Mr. Adebayo.
My lord, we are very, very, very grateful to your lordship for the well-considered judgment.
The alternative reliefs are granted.
Yes, my lord, sir. We are very grateful, sir. We appreciate your lordship, even considering the time your lordship had to spend on national assignments and to still come back and deliver this erudite judgment. My lord, we are very grateful. The claimants are very grateful. We appreciate your lordship, and once again, we thank your lordship.
Thank you, Mr. Adebayo. I appreciate that. Yes, Mr. Rwan.
Most grateful, your lordship, for the well-considered ruling. Really appreciate the indulgence of the court so far. Most grateful.
Thank you, Mr. Rwan. Azia.
Registrar Ajia.
Aja. Aja.
My lord is like.
Aja, you're sleeping on duty.
It's muted. I think she's connected now.
No, I mute it.
Okay, you're muted.
Yes, ma'am. Yes. Now I've unmuted myself.
So is there any other thing?
No. That's all for today.
Okay. So Mr.
My lord, I don't know how soon we'll be able to get the copy of the document, sir. Yes, sir.
Next week, God willing. By next week, God willing.
Inshallah, Lord.
Inshallah, yes.
As a basis. We are grateful, my lord.
Thank you, Mr. Adebayo. Mr. Adebayo and Mr. Rwan, that will be all for today.
Yes,
and
my lord.
I wish you a happy weekend in advance.
I wish my lord the same also. We are grateful, sir.
Thank you so much. So, bye-bye for now.
Yes, sir.
Bye.
Thank you, Aja.
Sir.
It's okay. Thank you.
Okay, sir.
Okay.
11:50. That's much.